Good evening and welcome to our revision lessons tonight. So tonight I want us to do something a bit different. I would like to engage you, take up the issues and the questions that you have, and then we will discuss them. But before that, in the last 24 hours, I've been thinking of asking you to read illegality very well in contract, okay? So read illegality very well in contract. And especially, you look at how the court treats the effect of illegality in Ghana along the lines of the City and Country West Limited versus the Accra Metropolitan Assembly. So just look at that well. Maybe in future, I will work out a question which be representative of what is required of that topic and put it there for us to discuss together. But I think it's a good area to look at well. So you can look at chapter 11 of Mrs. Duna Hamon's book. Is well treated over there. Okay. So having said that, I will now come to you. So if you have any particular question which you want to bring up, one person at a time, then we'll discuss it. And I'll be talking to you in all the sessions, so let me hear your issues.
Sir, good evening.
Good evening, Anna.
Yes, mine will be on constitutional law.
Okay.
So I look at it that if you look at the constitution, I've forgotten the particular section.
The particular provision or article. All right. All right, go ahead.
The particular article.
Yeah.
Yes. That talks about, I don't know whether it will be appropriate. That talks about citizenship of
citizenship of Ghana. You mean the citizenship start from chapter 3, that is chapter 6 to chapter 10. Sorry, article 6 to
citizenship.
10. Yeah. So article 6 to article 10, that's citizenship. And I look at the Citizenship Act as well. So the chapter.
Yes, you see.
Yes, go ahead.
You see, it talks about it that, let me use the two instances, either your both parents are Ghanaians or one of your parents is a Ghanaian. What is the source, or you see the document that we'll be using to defend that your parents are Ghanaians or one of your parents is a Ghanaian is the birth cert. But if the Supreme Court the Supreme Court ruling, it baffles my mind. If you could expatiate on it a bit for us.
Okay, so just before we move on, I have to read the decision in full, but not having read that decision in full, the initial comments will be that I think essentially what the court is trying to say is that citizenship is a legal conclusion, right? I mean, that is how we take it. It's a legal conclusion. That is to say that you must have certain facts or certain information. Then when those facts exist, on basis of that, you're able to make that a legal inference that if S, Y, Z, then you have a nationality or citizenship of Ghana. I think that is the broader jurisprudential appreciation of what the Supreme Court is trying to say. Yes. Yeah, as I said, I have to read that particular decision in full. I haven't read it in full, but the aspects that I am familiar with, and also, I mean, there is, I'm sure your interest has been aroused about the recent vetting of Her Ladyship, the new Chief Justice nominee. But of course, there's nothing wrong if it has excited your interest. But as I said, all that essentially trying to say is that, yes, I'm sure you're thinking about the birth certificate and then and all those things. So all that's trying to say that there are certain, you have like means of proving, right? Means of proving that you are a citizen. So if you take the chapter 3 of the Constitution, as well as the Citizenship Act, various permutations are be given regarding how you can establish that you are a citizen of Ghana. So in some respects, either by descent, that is, you can trace your ancestry as, you know, having been Ghanaians and so on, in one way or the other, either through your motherland or fatherland and so on, then you also acquire it. Or by the other processes, such as those who are not citizens by birth, along proof through the descent or the ancestry, then by naturalization, by registration, and so on. Yeah, so I think that the preliminary, those are the few thoughts that I will share. But as I said, that particular case will have to be read in full. So maybe we can share it. We can share that decision on the various platforms so that we will read them in full, and I can have like a mini session to discuss it and tease out the relevant issues which need to engage your attention for you. Yeah, so thank you. Any other?
Yeah.
Thank you,
Prof.
sir.
Yeah, Prof. Good evening.
Good evening, sir.
This is Joshua.
Joshua, okay.
Yes. I want to ask a question in connection with marriage. That has to do with dissolution of marriage.
You know something? Sorry, I would like us to concentrate on the 6 examinable subjects. That is
yes, that borders on illegality.
Oh, right. Okay. All right. That's yes. Fine. Okay. So go ahead.
I know that Supreme Court does not have a jurisdiction, territorial jurisdiction beyond Ghana. Now, I read the case of Akoto versus Akoto, okay, when illegality or fraud was involved, and that when fraud is involved, the jurisdiction of Supreme Court is beyond the extraterritorial boundary. I want you to give me more clarification on that.
Okay, if I understand you, well, I think your question seems to be that first, the jurisdiction of a Supreme Court, and for that matter, courts in Ghana territorial, that is to say that it does not go beyond the
territorial boundary.
All right, yeah. So that is correct. And then you brought up another issue that where the issue involved is fraud. Then
yes,
the jurisdiction is not just territorial limited, or it's not bound territorially.
Exactly. You are a smart judge.
No, see, I think what you rather, you see, there are two things. Let's suppose that a transaction transaction, be it the marriage or be it whatever, took place in another jurisdiction. And then there's a dispute about it in the court in Ghana. And in that transaction, fraud is alleged. Now, so long as the case is before a court in Ghana, the court will deal with it. But then you should know that there's what they call the conflict of laws or private international law. In appropriate cases, depending upon the type of transaction, issues of choice of law may come in. Choice of law, or what do you call it, the proper law, which governs the transaction of the contract. So if, for example, if it's about marriage, maybe somebody married that person outside Ghana, or married another person who is a foreigner. And later on, there's allegation that one deceived another or some other things. Now, you have to establish the law which governs the marriage. And that one is not just a contract, it's also an area of family law, and also conflict of laws. So there's something we call the lex loci celebrationis. That is the law which governs the celebration of the marriage. You have to establish that. And also the law which governs what we call the substantial validity. That is how you work your way around those matters. But as I said, since we are mainly in the area of the conflict of laws, I do not foresee that so long as we have not included conflict of laws or private international law in the examinable areas, you have to worry yourself so much about that. But if it's just for your general intellectual edification, you want to explore more, then that is fine. We can engage maybe at a later age, probably between you and me or another level, and then we talk about it. Okay, so any other question? Yes.
Prof, let me interject here, Prof. Okay. I'm asking because Hajia for real. There's a current case that who defrauded people in US in the name of sex. Had to do with sexual orientation or something. Can we consider it as well?
So if I understand you, you want to find out, for example, if Hajia for real, whatever, if assuming is in Ghana, can Ghanaian courts deal with her? Is that your case?
Certainly.
Yeah, I mean, if it's about, for example, if it's about marriage, you cannot misrepresent, you cannot tell a lie to get someone's consent. So that is one. And again, apart from the marriage context, if it's about any other criminal law, if you're defrauded by false pretenses, you have made someone to part away with his property or money as a result of your fraud or your pretensions, then within an appropriate set of facts, there can be criminal prosecution, and then we can go into the merits of it, as it were. Or outside criminal law and also outside marriage, we can also have if we have misrepresentation generally as a civil matter, either in contract or as it were. Yeah, so it depends upon a particular set of facts. At this stage, I noticed that you are still being at the very general abstraction level. You haven't actually zoomed in on a particular set of factual configurations. So, but it's good you exercise your, if you like, interest and curiosity around those areas. Yeah, any other?
Excellent.
Yes.
Yes. Yeah, somebody is asking, is this a lecture for law entrance? Yes, it's a lecture for law entrance, but this session, I'm just taking questions. We're doing questions and answers, Q&A session. So whatever you think you want to bring up for us to discuss together, which will benefit all those who are preparing, feel free. When I came, at least,
Yes, my lord.
Particular area I think you should watch out for. I'm not saying it will come, but I don't write exam, but when I had a dream last night, that I was writing the entrance examination, there was something on the illegality. So I said, okay, I'll tell my students about it. Yeah, I'm not saying there's anything, but just don't lose anything if you read it. Okay. Yes, another person.
Yes, my lord.
Yes, Mr. Fosu.
Yes, sir. My lord. Good evening.
Good evening.
My borders on the inquiry offense on bordered on the conspiracy.
Okay.
Conspiracy. Looking at what happened on the case of Afoko versus Asiki, I don't remember the actual name. The is becoming looking at how yesterday I read in the papers. I look at people are making a lot of funny about the judgment. They're looking at how can the two people conspire and one
is that not the trial judgment?
Yes, my lord. So the question is, should jury trial be abolished?
Yeah, so let me, okay, I will advise that cases which are live, okay, when you meet me, you don't bring up those cases because it can come before me and I'm not supposed to comment on them. But then you can have like your general questions. Okay, all right. Yeah, but I heard something from you that the jury trial, yes, so I think it's a worthy subject. I'm aware that the Attorney General, and then I cited the draft bill. They are trying to amend the Criminal Procedure Code further. And I think the jury trial is one of the candidates for reform. I will look at the portion of the bill which speaks to that, so that maybe later on when I meet you in criminal law or in legal system again, we can talk about it. Assuming, I mean, it's a good candidate for examination, isn't it? If you set like the example that he cited or some other examples and say that in the light of these decisions, there's a public concern that the jury mode of trial is not fit for purpose. And for that matter, you're invited to, if you like, make a case for or against, or submit a memorandum to Parliament or to the Attorney General as to whether the jury trial should be completely abolished or how should it be reformed. Yeah, so I think it's a good area for you to exercise your imagination on. Right, thank you.
Thank you, my lord.
Good evening, my lord.
Prof.
Let's take, I think we've managed to get one female voice. So let's take the female voice, then we'll take another one.
Hello.
Yes.
Good evening, my lord.
Good evening.
Please, I came across a certain question and I would like us to go through it if you don't mind. So I would want to read out the question. It says, discuss the relevance of the previous constitution in the resolution of contractual disputes within the context of the 1992 constitution.
Take it again. Discuss relevance.
Discuss the relevance of the previous constitution in the resolution of contractual disputes within the context of the 1992 constitution. I saw it on one of the platforms and I was wondering how, I really didn't understand the question.
Okay.
Thank you, my lord.
All right, thank you. I think if you have a question like she read, discuss relevance of the previous constitution in resolution of the contractual dispute within the context of 1992 constitution. I don't know if I captured your question well. Did I capture it well?
Yes, my lord, you did.
Okay, good. All right. So a question like that, I think two things. If it just say contract simplicity, okay, because as soon as you mention contract within the context of the constitution, our mind should go to two types of contracts. I mean, contracts involving the states, and then contract just between non-state actors, right? So if you are dealing with the contract involving the state, I think that is where the Constitution become really, really important. And remember the various cases, especially the provision which requires that you must get a parliamentary approval. You remember those things? Do you remember those issues?
Yes, Prof.
Yeah. So that
Yes,
is
yes, my lord.
Yeah. So I think that that is, if I understand what the questioner is trying to really discuss. So you may want to, for example, find out as whether that provision which requires, let me get the exact article, which requires that if there's a contract involving, if you like, the state, like especially foreign contract, right, involving like a foreign entity, you have to get like the parliamentary approval and so on. So you want to find out, if you look at the old constitution, like the 1979 constitution and probably 1969 constitution, did we have any similar provision, or these are novel provision? But my suggestion for you is that since you don't have the luxury of time, we have to make life easier for you as far as your revision is concerned. So one trick I will share with you is that some of these things, if you can get the Constitution Review Commission report, okay, it is in a PDF. So you know how to use the find. PDF, you can just enter a query, the particular thing you're looking for. So when you put the query there, it will just search it and then to bring it up. And then you click on it and the particular things that you're looking for, then you read. Now, in that report, in terms of these historical things, we know a lot of them have been organized in a very simple and succinct way. So they can just get your information right away and then you move on. And then to some extent, to some aspect of it, you have a Professor Tukuba's book too. You also get some of the historical aspects without wasting a lot of time reading a lot of pages. Just read about just a page or 1.5 page, and then you have the information that you are looking for. So that is it. But as I indicated, this question is good, but it is a question which requires, it's not we have a question we do within examination setting, okay? And so a question like this, to do it properly, you require access to your library so that you can do a proper thing. But it's good that you exercise your mind on it. But I doubt whether extremely general question, which requires a more detailed, specific comparative information in terms of what was in the previous constitution, in terms of what the Supreme Court has said regarding those provisions, whether you'll be able to do a good job on them within just the context of this type of examination. Yes. Any other? But then let me also say this, that apart from this observation I've made regarding the lady's question, when it comes to Contra 2, don't forget that apart from, those special instances where there's a contract between maybe the government and a foreign entity, you need a parliamentary approval and all that. Apart from that, all other contracts, the state is treated like a normal person, right? The state is treated like a normal person, so you have to remember that. So if you look at Article 293, right? Article 293 of the Constitution, for example, which talks about claims against the the government. And the point will be made that, quote, where a person has a claim against the government, that claim may be enforced as of right by proceedings taken against the government for that purpose, without grant of a fiat or the use of the process known as the petition of right, unquote. You know, in the past, at common law, there was what we call the petition of right. If you wanted to sue the state, if you wanted to sue the monarchy, you needed to get approval first before you could start your suit. But under our constitutional dispensation, the state can be liable like any other person under various transactions. So that is one thing you should note. The only difference is that there's what we call the State Proceedings Act at 555, which requires that if you want to sue the state concerning any claim or anything, you must give the Attorney General 30 days notice. So apart from that, the state can enter into any transaction and can be sued like any other non-state entity. So let's keep that in mind. Any other?
My Lord, Prof, I want to ask a question that has to do with the Chief Justice nominee.
Okay.
And that most often they ask questions regarding the current issue trending.
Okay.
And then the question earlier on asked by one of our colleagues here regarding the very question you said could come to you in court as a case.
Okay.
And then also the birth certificate issue.
Right.
I am very certain that they can bring it because it's a very topical issue trending now.
Okay, my quick reaction to your hiding degree of certainty and conviction that such a question will come is that last year and even the last 2 years, when COVID-19, right? When COVID-19 was all over and all that, we highly tipped the doctrine of frustration, frustrated contracts, right? It didn't come. So when you are so expecting particular area, it will not come. And that is why in my earlier session, those of you who attended or who have listened to the tape, I gave you a practical advice regarding how to prepare so that you know that you are not going to get 100 over 100, but at least you can get your 60 or 70%. I told you how you should go about that. That one is safer than just pinpointing that this will come, and then you spend all your energies on only that. And you don't prepare on other areas. And then other areas that you don't prepare, you go and then the question will come from there. And may even be, if you like, a very simple elementary area, but just because you didn't revise, you will struggle to write a meaningful response. Okay. Yeah, Amma, Puma, you can have the floor now.
My Lord,
Prof, good evening.
good evening.
Prof, good evening.
Then I called one lady. She's raised up her hand for a long time. Amma Puma. So let's finish with her.
Yeah.
And then when we finish, we
Yeah.
come to one question in the chat. Franca, yes.
Yes, my
Amma
Lord, this
Puma,
is
yeah.
not Amma. That's
Oh, right,
my
but
wife.
that's the name I see. Okay.
That's my wife. Yes.
Mr. Sechimensa, all right, go ahead.
Prof, Prof, the question I'm asking is about if you take the directive principles of state policy, and I
Okay.
want to engage your view, because if you look at the SIBA case that Justice Databan was with the view that and the 31st December the judges were with the view that if it was the whole constitution was a justiciable,
Yeah.
document. In your view, do you think the directive states principles, the chapter 6, is this justiciable?
Okay. All right. Thank you. And I'm sure you also mentioned the Lotto case, so you left it out. So the current thinking is, initially there was 2 schools of thoughts regarding justiciability of the directive principle of state policy. That is to say that, can you go to court and mount an action on directive principles of state policy? One school of thought said that no, because it was just aspirational. It constituted a statement of the vision of society we are trying to build. And for that matter, it was not justiciable on its own. Another, unless you could actually, if you like, peg it to maybe some other areas. Another school of thought said that no, so long as Article 2 of the Constitution says that if you allege that anything is done or omitted to be done is in contravention of the Constitution or is inconsistent with the letter and spirit of the Constitution, you could come to the Supreme Court for declaration to that effect. So by parity of reason, Chapter 6, which is the directive principle of state policy, is also part of the Constitution. So how can you pick and choose and say that that is not enforceable? So these were the 2 schools of thought. But then, if you take the Lotto case, for example, no, the Supreme Court has authoritatively, if you like, clarify that the Chapter 6 is justiciable in conjunction with other areas of the Constitution, as it were. So that is the current thinking now. But then there are some of them, for example, let me take Article 41, right? If we take Article 41, we'll talk about like the duties of a citizen. The duties of a citizen. I'm wondering, if you go to court, you go to court and say that because a citizen has not paid his taxes, or because a citizen has created a nuisance in his community, he has not lived up to the duty enjoined upon him or her by Article 41 of the Constitution. And for that matter, that is unconstitutional. You know, there is something you call the law is not about trifles. It's not about minor things. The de minimis principle. The law is about serious, substantial matters. Yeah. So you are right. The effect of this case culminating in the Lotto case is that the directive principle of state policy, there's a presumption of justiciability. So that is the conclusion, that there's a presumption that it is justiciable. And that presumption is a rebuttable presumption. That is to say that, like the example I gave you, you can bring up a particular directive principle of state policy. And if you examine the nature and the content, the scope of it, it will tell you that this particular directive principle is not really enforceable per se. But then the starting point is that all the directive principles of state policy are justiciable. Yeah, so that is it.
Okay.
I think another, yes, there's a question.
Prof, good evening.
Yeah, if it's a new question, let me take a Franca's question. Franca has a question in the chat box. Please, what is the implementation process for subsidiary stroke delegated legislation? Good, okay. Franca, I don't know if I understand your question. Are you talking about the process of passing or making subsidiary stroke delegated legislation, or its implementation? Can you clarify so that we answer it? the process of making it. Okay, good. So as we know, delegated legislation, also known as a subsidiary legislation, refers to the various laws which are made under a power conferred directly by the Constitution, in which case it will be constitutional instruments, or made under a power conferred by an act of parliament. And we have like the various examples of that. I have the legislative instrument. Maybe you have like an act of parliament which says that the minister or anybody given power under it we make regulations in the form of legislative instrument to provide for some detailed matters. Or I was just working with the Companies Act, for example. If you take the Companies Act 2019, Act 992, and if you look at the section 381, okay, it's headed regulations. And I just quoted for your example. The minister may, on the advice of the board, by legislative instrument, make regulations regulating the exercise by the registrar of any of the powers and discretions conferred on the registrar by the act. Then it goes on. Yeah, those who follow the lesson we did on the sources of law in Ghana legal system, we haven't finished this bit in the subsidiary legislation. So next time I come back to regular presentation where I'll be doing the teaching, and we are doing Ghana legal system, we will continue with that. And there are some points which need to be articulated there. But just for your present consumption, Franca, there are various types of subsidiary legislation or delegated legislation. And if it is, let's say, bylaws, right? Bylaws are made by district assemblies, municipal assembly, metropolitan assemblies. If it is what you call the LI, legislative instruments, they're usually made by the sector minister or another sector minister, as the case may be. Maybe minister for this, minister for that, depending upon the thematic area of that legislative instrument. And then if you take constitutional instruments, you take the Electoral Commission, for example, right? Electoral Commission, for example, makes rules to govern the conduct of elections by means of constitutional instruments. Now, whether you are dealing with constitutional instrument, bylaws, legislative instruments, and all that, since they are all subsidiary legislation, according to Article 11 of the Constitution, I think Clause 7, they are supposed to be laid before Parliament and also gazetted. And are supposed to be laid 21 sitting days of Parliament. And if you go to Parliament, there is a committee we call the Parliamentary Committee on Subsidiary Legislation. So all subsidiary legislation are supposed to be reviewed by them. But unfortunately, if we look at Article 11, Clause 7 of the Constitution, only one of two things can be done. One, if they want the particular subsidiary legislation to become law in Ghana and be binding, they don't have to do anything and allow the 21 sitting days to elapse. And then automatically, once it has been gazetted already, to assume the force of law. Or if they are not happy with it, you will just have to trigger the process of the procedure for annulling it. But they cannot change even a sentence or two. So that is the thing. They cannot even change a sentence or a comma. Because if we look at 11 Clause 7, it's quite limited in what they can do. because it says that annuls the other rule or regulation by vote of not less than 2/3 of all members of parliament. So the requirement of really laying subsidiary legislation before parliament, if you like, is just cosmetic. Cosmetic in the sense that unless parliament is really minded to marshal 2/3 of its membership to vote and annul it so that it does not become law, automatically after expiry of 21 days, it will become law. So probably if you are thinking about how to reform the making of subsidiary legislation, this is one particular area that we should think about. That is not enough just to put the constitution that 2/3 can annul it. I think they should be giving more powers probably to. So maybe the practical solution would be that where the parliament has a strong consensus about it, they can probably advise the sponsoring body, which brought the subsidiary legislation, to either withdraw it and go and rework it and lay it again. I mean, that is the practical working solution. I think there's another, yeah, somebody wanted to ask a question.
Yeah, Prof.
Yes, go ahead.
Yeah, my question has to do with the subsidiary legislation. For
Okay.
instance, in the Procurement Act of 2003, as amended in 2016, the Section 19 talks about qualified procurement, qualified procurement officer, not a professional procurement officer, qualified.
Okay.
And that the chief executive has the power to appoint such a person. I want to know if it falls under the subsidiary legislation, please.
Oh, no. Please, let's remember this. And I think the Supreme Court has actually come up with the decision. I think the lead opinion was about, I think Justice Kulendi or yeah. If you talk about as whether something is a subsidiary legislation, you must ask yourself, is it of legislative character? Legislative character means that, is it making law? If it is just implementing or taking, if you like, certain measures which are purely of executive character, it is not subsidiary legislation. So, like the example you asked, I don't see any thing in the nature of being of a legislation or making law. So that will not be example of a subsidiary legislation.
Okay.
Then I think somebody has a question that please understand there's a hierarchy within the source of law, and there's a formula for resolving horizontal and vertical inconsistencies in law. Can you explain what that formula is? Okay. Okay, all right, good. So if you take Article 11 of the Constitution, you notice that we are told that the source of law in Ghana are the Constitution and then in that order. And there are some decisions by Supreme Court, and I think recently Justice Duche wrote one of the lead opinion saying that if you look at that, one would not be wrong to assume some hierarchy of legal norms created within the listing. So the Constitution certainly is number one. The Constitution is if you like, the first in the hierarchy of laws in the country, and certainly followed by Acts of what? Parliament. Followed by Acts of Parliament. Except that And maybe the little tweaking we'll make is that the Act of Parliament, you may also put on the same pedestal the existing law. You know, if you go into Article 11, the what you call the existing law. And the existing law, we are talking about all the laws which were enforced in Ghana before 7th January 1993. All the laws which were enforced in Ghana, they are called the existing law. Certainly, some of these laws are acts of parliament, that is acts of the old parliament, and decrees. So they are more or less on the same pedestal with enactments because they are all acts of parliament. The only qualifier is that the existing law must be compatible with the letter and spirit of the 1992 Constitution for them to remain as forming part of the corpus or the body of laws of Ghana. That is the only thing. And then after that, we have like the common law of Ghana. We have like the common law of Ghana. We have the, if I say the common law of Ghana, we've talked about it a couple of times, the common law, doctrines of equity, and then principles of the customary law ascertained by the superior courts. And then we also have the subsidiary legislation or the delegated legislation that we are talking about. Yeah, so coming back to your horizontal and vertical inconsistency. Well, that is a very beautiful mathematical imaging, but the bottom line is that all laws must be in harmony with the letter and spirit of the 1992 Constitution. I think that is a non-negotiable doctrine. And the rest just follow. If you take subsidiary legislation, according to the doctrine of ultra-vires, you cannot make a legislative, a subsidiary legislation, which, for example, seeks to do that which the parent legislation, the particular act of parliament has not authorized it to be done, then that will be ultra-vires. It may not necessarily be in violation of the Constitution, but it will be in violation of the parent act, the enabling act, which enables that particular delegated legislation to be made. So let's keep that in mind.
Okay, Prof.
Yes, Ebenezer.
Yes, sir. Prof, mine has to do with looking closely at the way elections with respect to parliamentary election disputes are conducted. If you take a closer look at
Your voice is going down.
Parliamentary election, Zakaria and Makai. I'm respect to parliamentary election petitions. Please,
Okay.
can you hear me?
Yes, now.
Yes, parliamentary election petition.
Yes.
After reading INRI parliamentary elections for Wellency constituency, Zakaria
Yes.
and Nimakai.
Yes.
And just opposing that one with James Kwachi Quincy. Under what circumstance with a parliamentary election dispute, which we know that after it has traveled from the High Court, the final court will be the Court of Appeal. Now, with respect to James Quincy, it went to the Supreme Court. And I know Article 99 talks about the Court of Appeal being the final court when it comes to parliamentary elections. May I know the circumstances under which a parliamentary election petition can travel from the High Court and then gets to the Supreme Court when the Court of Appeal in Article 99 has been designed to be the final Court of Appeal?
No, but you see, please, let's get certain things clear.
Okay.
If we are talking about qualification, right? Who qualifies to put himself or herself up for election? It's not just a matter of parliamentary dispute.
Candidate.
It's also about the enforcement of the Constitution. And where you have any interpretive like issue, of course, don't also forget that that particular one, there was a, then it went through the judicial review route, if I am not mistaken. It went through the judicial review route. And if it didn't go through judicial review route, anytime there is a constitutionality in relation to parliamentary election or anything, it can always go to Supreme Court. So that is one thing that we have to remember.
Then, Prof, to add up to my colleague's question,
yes,
the situation where it went to judicial review, and then the same candidate whose matter is now in the Supreme Court want to contest again, and that after he submitted the application to Canadian Embassy, the Canadian law is that immediately you submit to renounce, you are no more a citizen of Canada. So whose country citizen is he now? My Lord.
No, but I think that his particular case, it's with respect to the time that he filed his nomination in Ghana. I think what his circumstances were at that time is what actually led to the current decision of, I think, the court. And of course, after that, there might have been changes. If it is true that he was trying to take steps to jettison or abandon his Canadian citizenship, certainly he might have completed the process. And if he's completed the process, then he's not a Canadian citizen, he's a citizen of Ghana. And that is it. But I think the case relates to at the time that he filed nomination, or he filed his application to stand for the election. Was he a Ghanaian, or he had a citizenship of another country? I think that was the matter. For now, yes.
My question is not properly answered, Prof. I'm asking that
you have the answer. You have the answer already.
No, my issue is
that
the position of the Canadian law is that it's just like the postal rule that immediately the letter is posted, there is communication. Adams versus Lenso. Now, in Canadian rule is that immediately you send your letter to the very office, you are no more a citizen of Canada.
The letter of renunciation, you mean?
Yes. Immediately it gets to them in Canada, you are no more a citizen. Whether you have received a reply to that effect, you are no more a citizen of that state. And
please,
I'm asking
please, are you talking on facts, or it is just something you are saying?
Speculation.
Please read what the court.
Have you read the judgment?
Please, what the no,
of course, we are waiting for...
was saying that.
Yeah.
But for relax for him. He is talking about Canadian law, not the judgment of the court.
No, Canadian law.
Right. So he knows that that is the position of the Canadian law.
That's what I'm saying.
Not Daniel law and not the judgment.
So
all right. Okay. All right. I don't know the position of Canadian law unless I look at it.
Because he's no more a citizen of Canada. Let's leave the Ghanaian Supreme Court judgment. Which country citizen is he? That is the question I'm asking.
All right. So you want to find out whether he would be able to go like a stateless person. You know, international law, there's this concept of statelessness, a stateless person. Well, I don't have all the facts, so we cannot make like a definitive conclusion on it, but that's an interesting academic exercise. I think someone has a question.
He was already a dual
there's
citizen.
a question. Let's look at it. Somebody has a question. What's the first one? I see only the number 2. Is there any contradiction between natural justice principle of nemo iudice in causa sua, meaning no one is a judge in his own cause, and Article 126(2). Who is the questioner? Okay, all right, Emmanuel. Article 126(2), that the superior courts shall be superior courts of record. They shall have power to commit for contempt to themselves, and no such powers as were vested in the courts of record immediately before the coming into force of this constitution. So if I understand your question is that is there any contradiction between the natural justice principle that you should not be a judge in your own cause, and also Article 126(2), which says that the courts have the power of contempt? Is that your question? Oh, okay. All right. Good. So, of course, we all know the natural justice principle, nemo iudice in causa sua, that you cannot be like a referee and a player. You cannot be a judge in your own cause, decide over a matter in which you also have like an interest, or you are related or have some bias, and so on and so forth, as it were. Good. Now, Article 126(2) talk about the fact that the superior courts of the judicature, that is High Court, Court of Appeal to the Supreme Court, they have what we call the powers of contempt. That is, they have the inherent power to actually bring the authority of the state to discipline anyone who would like to undermine the dignity and majesty of the judicial system. Because the policy rationale is that the courts are our last resort. If people should lose confidence in the efficacy of the courts, then there'll be chaos. And that is why, if anyone is showing disrespect to authority of the court, not the person of the judge, so contempt does not protect like the person of the judge, but the office which the judge occupies. So that is the idea. Now, there are various types of contempt. Don't forget, we have contempt, in facie, contempt, ex facie. We also have the criminal contempt and so on. So contempt, which happens like in the face of the court, on the presence of the court. Let's say that you are around the court premises, and in the courtroom, maybe you are making noise, knowing that the court is going on, proceedings are going on, or you go to the courtroom, put up a very insolent, disrespectful poster and all that, and the court sees it and all that, you can be cited for you to actually show cause why you should not be punished for contempt of court. So your concern is, yeah, so I get your point. So maybe the mistake you're making is that you're taking the view that the judge who is going to decide the case is also the person who is at the center of the whatever the person did as contemptuous. So can the alleged contempt? No. Can he get fairness in the adjudication? Is that your concern? Is that the question, Emmanuel? Yeah, Emmanuel is not talking. Okay.
Yes, my lord. And on that case,
yeah,
my lord, on that case, I remember Kenneth Japan case when he insulted the High Court judge and he was charged for contempt. The Supreme Court came out with a decision that there was a clear likelihood of but there will be a clear likelihood of bias, and therefore the judge in question could not have sat on the case, and therefore for that contempt case, therefore, and it should be rather given to another judge to sit on that case, since that judge who was insulted will be more, there will going to be more kind of likelihood of biasness in the decision. Emotional, yes. So he couldn't have sat on that case. So, if I got what my colleague, the question colleague asked, when it comes to the Supreme Court, that one may not be the case. But when it comes to the Supreme Court decision, which was recently, I think in 2021 or 22, very recent. If he bordered on the High Court, then that particular judge, the judge is immune or bound to sit on that case. Rather, have to be given to another judge to sit on the case when it's come to contempt on that matter, if my memory sets me right.
But there is a practice directive by the CJ, which now makes it possible for the same judge whose orders have been disobeyed to actually adjudicate the contempt in the same case. You don't even have to start like but these are civil procedure matters, so don't let us worry your head, and let's just concentrate on the things which will let to pass the entrance.
Thank you, my lord. Thank you.
Okay, my lord.
Yes, we have just about 2-3 minutes went. It's 10:05.
Okay, my lord.
Yeah.
My own is linking to contempt with vicarious liability.
Okay.
Yeah, when an officer of an institution,
yes,
is given mandate to go to court and work on behalf of that institution, when the said officer comes into the courtroom, and in the process of conduct, working out for the institution, happen to be in the grip of contempt. So, how will vicarious liability play? I'm talking about master servant.
I understand your point. Let us remember, dear friends, that the doctrine of vicarious liability applies to civil wrongs, right? Not to criminal wrongs or criminal offense. In other words, where you are working in the course of your employment of your master or your employer, and you commit a crime, when you are arrested and you are being prosecuted, you don't say that, well, I was just an agent, or I was just doing the bidding of my employer. So whatever I did, it was not just for my benefit, it was within the course of my employment. So hold my employer or my master responsible. No, it doesn't apply. It applies to civil wrongs. Typically like torts, as it were. So let's keep that in mind. So for criminal law, if you're an employee and you commit crime, you commit murder, you commit anything, you will not be exculpated by reason of vicarious liability, that we should visit the consequences of your criminal behavior on your employer. It doesn't work that way. Okay. Okay, so we will draw the curtain down here tonight. Have a good night, and we will reconvene.